Good morning, everyone. My name is John Bolger, and I will conduct this meeting today as chairman of the State Ethics Commission. I have a couple statements that I will read, and then we will go from there. Pursuant to the Public Official and Employees Ethics Act, Act 170 of 1978, as amended by Act 9 of 1989 of June 26, 1989, and as amended by Act 93 of 1998, the State Ethics Commission is specifically mandated to hold at least 2 public hearings, each of which at least one shall be held in Harrisburg and at least one shall be held in a location other than Harrisburg, to specifically seek input from persons and organizations who represent any individuals subject to the provisions of this act and from other interested parties. We have placed on the agenda for today's public meeting a notice that the Commission will be meeting today in part to receive the input or testimony of said individuals pursuant to the provisions of the law. As our previously published notice has indicated, the Commission will request copies of any statement that is presented. The individuals presenting statements before the Commission will be allowed 15 minutes in order to complete their statements. Statements shall be uninterrupted, except that such statements may be interrupted or terminated by the presiding officer if it is determined that the statement is impertinent, scandalous, or otherwise improper. The next statement that I will read: pursuant to the requirements of the Sunshine Act, the holding of an executive session must be announced at the public meeting immediately prior to said executive session or at the next meeting thereafter. Executive teleconference meetings were held on July 12, 2012, July 24, 2012, August 13, 2012, and August 17, 2012, to review matters that are by statute 65 PA CS number 1108 AC confidential, including the review and consideration of applications for 90-day extensions of investigations filed by the Investigative Division, to receive legal advice and discuss possible litigation and/or complaints in connection with correspondence the Commission received from President Pro Tem Senator Scarnati. An executive meeting will be held on September 24, 2012, immediately following this public meeting, to review matters that by statute 65 PACS number 1108 AC confidential, including the review and consideration of applications for 90-day extensions of investigations filed by the Investigative Division, the review of completed investigations for the purpose of issuing final adjudications, the consideration of assigned reviewing commissioners' recommendations to terminate certain preliminary inquiries, and the review of pending legislation. That concludes the 2 statements that I'll read. The first order of business today is we would like to welcome our new commissioner, Mark Corrigan, who will be serving his first meeting. Mark Corrigan served 30 years in the Pennsylvania Senate, and we welcome you, Mark, to our commission.
Thank you, John.
With Mark's appointment, Chairman Fryman is now no longer with the commission, and as has been our history in the past, we have a plaque that will be presented to Mr. Fryman, and I will read it to you, but I can tell you no plaque is big enough for the work that Commissioner Fryman did for this commission to put the words on a plaque. There's no plaque big enough. He was an outstanding commissioner, and I would like the minutes to show that we are all in agreement as to the fine job of Mr. Fryman as a member and as chairman. The plaque reads, Louis W. Fryman, Esquire, Commissioner, March 9th, 1998 to July 1, 2012. Chairperson, May 2nd, 2002 to July 1, 2012. In recognition and appreciation of dedicated and tireless service to the citizens of the Commonwealth of Pennsylvania, presented to him by members of the State Ethics Commission. This plaque will be delivered to Mr. Fryman with our special thanks for the fine job that he did during his term of service with this commission. Okay. Having said that, I'm going to exercise the prerogative of the chair. First, I have one housekeeping item that I would like to do before we move into the public session. I'd like to approve that you've all received the minutes of the April 12, 2012 meeting. Do I have a motion to approve those minutes?
Second.
Moved and second to approve those minutes. Any questions? Comments? All those in favor, say aye.
Aye.
Any opposed? Minutes approved. I said I would exercise the prerogative of the chair, and we'll take some things out of order today based on people's busy schedules. And the first item on the agenda will go to public comments immediately and proceed from there. So it's my understanding that Mr. Haverstick and associate are prepared to address this commission.
That's correct, Mr. Chair. My colleague, Mark Seiberling, is here with me.
Pardon me?
My colleague, Mark Seiberling, from my law firm, is here with me. May we come up to the table?
Yes, please. I have to tell you, it's good to place a face with a name since we've exchanged many letters recently, and since you have a case before us on the open record, I guess this will continue. I guess you would say we're becoming pen pals. But we're happy you're here today, and we'll look forward to hearing from both of you. Please give your name and address for both you and your associate, and we'll go from there. You have 15 minutes, as I said in my opening statement. You can take less, of course, and when we're completed with your information, I will open it up to the fellow commissioners to question you on your remarks.
Thank you, Mr. Chairman, and Commissioners, Ms. Hitty, Mr. Contino. My name is Matt Haverstick, H-A-V as in Victor, E-R-S-T-I-C-K. My colleague is Mark Seiberling, S-E-I-B-E-R-L-I-N-G. We are from the law firm of Conrad O'Brien, principal address 1500 Market Street, 39th floor, Philadelphia, PA 19102. And as I believe the Commission knows, we represent the Republican caucus of the Senate of Pennsylvania. Now, Mr. Chairman, I did not prepare remarks today. My intention was to have a conversation with the Commission. So I do not have a statement from which I will read. Instead, I wanted to talk, not at you or to you, but with you about the issues that are before us. Is that acceptable?
Well, we're anxious to hear what you have to say. It's not a case where you question us, we'll question you.
And that's my point. I anticipated not that I would read a statement to you, but that we would have a conversation. And therefore, I didn't write out something I was going to say. I just want to talk.
That's fine. Please proceed.
Thank you. I'm here today on behalf of the caucus to talk about an issue that matters a great deal to me as an attorney. I understand it matters a great deal to the Commission, Ms. Hitty, as an attorney. And frankly, I think for the Commission, it should be of paramount importance because I believe it involves how this good body might be perceived in the world and within its jurisdiction, that is, among the individuals and institutions it regulates. Of course, we're talking about, and I'll get right into it, the legal bill that was received by the Commission from one of the Senate Republican caucus's outside counsel. This counsel, you all may know him or know of him, is former President Judge of the Commonwealth Court, Joseph Doyle. Joseph Doyle was retained by, and his law firm, was retained by the Senate Republican caucus to assist the caucus during the investigation of former State Senator Jane Orr. Mr. Doyle was performing services for the caucus and, of course, in the ordinary course, billed the caucus for his work. In late 2010, early 2011, one of Judge Doyle's legal bills relating to this work accidentally made its way to the Commission. Like any legal bill, this one contained sensitive attorney-client privileged and work product privileged information and material. It discussed the things Judge Doyle was doing on behalf of the caucus, with whom he was meeting, the documents he was looking at. In short, it contains the type of information that all of the attorneys in this room would expect and understand would be confidential. Clients of attorneys would expect and understand it would be confidential. And frankly, the law recognizes are confidential. Our Commonwealth Court has held repeatedly that the detail in a legal bill is confidential and attorney-client privilege. Now, to the Commission's credit, when the legal bill came in, its first stop got it to a staff attorney at the Commission who did the right thing. He contacted Judge Doyle's office, and he let the judge's secretary know, Your Honor, we received the legal bill. Clearly it's an accident. It happens all the time. We're going to send it back to you. And that's just what he did. He sent it back to Judge Doyle. At that point, the episode appears to be over. But we come to learn later that it's not. And this gets into sort of three problems that I'd like to articulate, and three concerns and mistakes, frankly, I believe the Commission may have made in its dealings with this legal bill. Mistake number one, copies of the legal bill, an acknowledged privileged confidential document that was returned to Judge Doyle, and with the understanding that it was returned to Judge Doyle and that was the copy. Copies nonetheless were kept by the Commission. Without explanation, without articulation, without Judge Doyle's knowledge or the caucus's knowledge. Then there's a communication between the Commission and the Allegheny County District Attorney's Office, who at that time we all know was investigating and prosecuting former State Senator Jane Orr. The circumstances for that call, well, we don't know how that happened. We don't know why it happened, but it did. That's the first mistake. The second, as a result of the communication, as a result of the Allegheny County District Attorney's Office knowing and learning that the Commission possessed a document that everybody understood to be privileged and confidential, the DA's office issued the Commission a trial subpoena for that document. Mistake number two, no one at the Commission ever let Judge Doyle know or the caucus know that this subpoena had come in and that the Commission was going to turn it over pursuant to the subpoena. In short, neither Judge Doyle, his law firm, nor the Senate Republican caucus ever had an opportunity to throw up their hands and say, wait a minute, we object. The caucus wasn't asking, and isn't asking, and it wasn't expecting that the Commission not respond to a subpoena. But what it should have done was let the interested parties know that there was a subpoena, and if they wanted to object, they had to do so in however many days, 5 days, otherwise the document was going to be turned over. That didn't happen. And finally, we get to mistake number three. And this perhaps is one that I think implicates the bigger picture that we have with respect to the Commission, that is the caucus. This matter didn't come to the attention of either Judge Doyle, his law firm, or the Senate Republican caucus until over a year later at the sentencing of Senator Orr. At that time, it first became known that the DA's office had a copy of the legal bill that everyone had expected had been returned to Judge Doyle without any copies being made. The District Attorney's Office conceded that they had received that document from the Commission, that they had been informed by the Commission of the document's existence, and that they had in turn subpoenaed the document from the Commission. Now, naturally, the Senate Republican Caucus was concerned about this. It was concerned that it didn't know that this had happened well over a year before. It was concerned that it had never been told. It was concerned, bluntly, that in 2011, that Commission personnel were apparently serving subpoenas on behalf of the Allegheny County District Attorney's Office, not Commission subpoenas, on behalf of the DA's office. So we asked questions. I wrote this commission, I wrote Mr. Contino, and I copied the commissioners. And what I thought was a straightforward letter asking for an explanation. No response was forthcoming. I wrote a second letter, again asking for an explanation, an articulation of how could this happen? Why didn't we know? Why weren't we told? I didn't get a response, nor did the caucus. I had to write a third letter. At that third letter, I asked for permission to speak at the next public hearing, and you kindly gave it to me. But I didn't get a response, nor did the caucus, nor did Judge Doyle, to the why, the important question of how could this happen? It was only after Senator Scarnati himself, the pro tem, wrote to the commission and asked for an explanation that at least some was forthcoming. But in the caucus's view at that point, the explanation and the response wasn't satisfactory. It was viewed as wagon circling. It was viewed as defensive crouching. Perhaps even a bit of bullying. And to this day, we still don't know important answers to questions about how this happened, why it happened. That's the reason that the right to know request was generated. We're trying to find out and get an answer because no one will tell us how this could happen. So I've articulated 3 mistakes we believe the caucus made, or we believe the commission made with respect to this matter. Was the commission's response to these series of events legal? Was it within strict accordance of the rules of civil procedure, criminal procedure, rules of professional responsibility? Frankly, I think that's a jump ball. I know Ms. Hiddy has an answer, and Alicia has an answer. I know we probably disagree. Parenthetically, I would say the time for the legal analysis by the commission on whether this was within the letter of the law should have been in early 2011, not in summer of 2012, when the caucus first raised the issue and found out about this. But let's set that aside for a minute, because I don't want to have a legal debate with you today. The question I'd like to put before the commission is, was this ethical? Was it right? Does this sit right the way this happened? I view, many in state government view the commission as the poll star, and I know the commission sees itself this way, the poll star of ethical conduct in the Commonwealth, as the guardians and the enforcers of ethical conduct, not just in substance, not just in the letter of the law, but perhaps more importantly in appearance. Is what our elected officials, is what our public officials doing right? Does it look right, even if it meets the strict letter of the law? That's one of the commission's most important functions. The caucus feels, Judge Doyle feels, and I'm speaking for him right now, that this wasn't right. But I'd ask you to make your own evaluation of that, not just listen to what the caucus feels. I'd ask you to ask yourselves, as individuals, either in your public or your personal capacity, if your privileged, private, attorney-client, or work product privileged legal document was accidentally turned over to another body, and your private, privileged document was copied after you believed it was returned to you, was disseminated to others without your knowledge, was subject to a subpoena without you being given the chance to object to that subpoena, And then finally, when you found out about it a year later, you weren't given a straight answer or an apology about why this happened. You couldn't get any answer. Would you all feel that you have been treated fairly or ethically? Would you all feel that the right thing had happened? I submit to all of you that that's the test that should be applied to this situation when considering big picture what happened here and the concerns of the caucus and the concerns of Judge Doyle. Now, what does the caucus want? Two things. It believes it's owed an apology. It believes it's owed an apology for the way this happened in 2011 and for the way it was handled after that. There's nothing wrong in life with saying you're sorry when you make a mistake, even if it's unintentional, even if it was in good faith. Mr. Chairman, you and I know that better than anybody. I apologize to you in writing just last week for an error I apparently made in a letter about notice of this meeting.
But you challenged the address that we sent it to.
I did,
Okay.
but I said I was sorry. I said, if I'm wrong, I'm sorry. I don't know how this happened. You say you sent me the letter. If you did, I'm sorry. And I am. Because we're human, we all make mistakes. And the more
Sorry for what?
I challenged whether I had ever been given formal notice of this meeting, Mr. Bulger correctly referred me to a letter that had come from Mr. Contino that we couldn't find in our office. I have no reason to disbelieve that Mr. Contino didn't send that letter. We just didn't have it in our office. So I wrote the chairman and I said, I'm sorry. I apologize. If this letter was sent, the fact that we don't have it doesn't mean I'm not sorry for saying you never gave us notice. The other thing I think the caucus is looking for, and this is really an institutional issue for the commission, are safeguards that this doesn't happen again. Again, setting aside the legal niceties of what happened here, if it doesn't sit right with you, if it feels off, if it feels funny, if it feels like, you know what, we could have done this better, then I think it's incumbent on the commission to make sure it doesn't happen again, that there are safeguards that prevent this type of thing from happening again. We're talking about real people, and real privileges, and real rights. And I know this commission values the attorney-client privilege as much as the caucus or Judge Doyle does. We're having a disagreement right now in the open records case over what I believe to be a good faith invocation of the attorney-client privilege. It matters. It matters. It matters to people. It matters to organizations. And it shouldn't be blithely or casually disregarded. And so we'd ask that the commission seriously consider the two requests the caucus has made today. I think they're important to the folks and the entities you regulate, having the confidence that you truly are the poll star, the arbiters of what's ethical, what's right in the Commonwealth of Pennsylvania. I thank you for giving me the opportunity to come in today and to talk to you. I did really envision this as a discussion, and I'm more than happy to entertain any questions you have about this at this time.
Okay. Thank you, Mr. Avstick, and your associate. It puzzles me that you continue to criticize this commission for cooperating with law enforcement agencies. And this is what I shared with Senator Scarnati when he asked me and our counsel and Commissioner Colafello to meet with him. It puzzles me. That's our job. That's our mission, cooperate with law enforcement agencies. So I just want to say that. Insofar as if we did something wrong, we would say we did something wrong. But as I said to Senator Scarnati, and I'm going to say it here today publicly, in my opinion, this commission And this staff has done nothing wrong during this process that you referred to. So I would just like to share that with you. I see you both writing something down, and so that's fine. Now, I would like the opportunity for our fellow commissioners to respond to some of your comments and some of previous correspondence that we received from you.
Certainly. Allow me to respond, and what I'm writing down is cooperation with law enforcement. We take no issue with the Commission's cooperation with law enforcement. We understand, under the Ethics Act, that's an important component of what you do. It's not the cooperation with law enforcement that concerned the caucus. It's the manner in which privileged confidential information was treated. There are rules in the criminal justice system for both sides on the way evidence moves back and forth. There are ways things are supposed to happen. Parties should be given opportunities to assert rights. Doesn't mean that you shouldn't and won't continue to appropriately cooperate with law enforcement. Please don't confuse my comments today or any previous comments as attacking the Commission for cooperation with law enforcement. Art?
That's the way it comes across. I can't speak for my fellow commissioner. That's what I feel.
Our concern,
Especially in a lot of the correspondence and some of the things you said today.
our concern, to be very clear with the Commission, our concern is the manner in which an acknowledged privileged document was treated. If the Commission receives a subpoena for a document, of course it's obligated to turn it over, provided that anyone who has an interest in that document has had an opportunity to assert objections to that document. That's our issue. It's one of process. It's not one of substantively how this Commission interacts with law enforcement. They're two very different issues, sir.
Okay, thank you, as I said again. My fellow commissioners, now is our time to ask. Yeah.
Mr. Chair, I actually would like, I'm one of the non-attorneys here, so I'm going to ask some questions that I think will help me understand as a commissioner maybe where we are and hopefully shed some light or at least open some areas of discussion. So let me, about a month before the invoice was sent to us, Judge Doyle submitted an affidavit that has your name on it, that detailed his work for the caucus. It explained documents that he had reviewed and things that he had done for the caucus. And those things were filed that then became part of open record. Okay. And then following that, there was a newspaper article that also talked about Judge Doyle's review of the caucus documents and the support that it provided in the Ori trial. Is that correct? Are you aware of those documents?
Yes, and if I'm not going to challenge your timing of the sequence of events. I mean, that sounds right.
Month, 2 months,
Sure.
you know, so sure. But those documents exist, and in effect, that information that was contained in the bill, what documents were reviewed, what things were looked at, became part of the record, of public record at the point that filing was made. Correct?
The documents certainly that were filed as a matter of public record, although I don't recall if they were filed. Let's assume they were filed not in a grand jury docket, but in an open docket. Then those documents themselves, absolutely, they're viewable for everybody.
How did the name of the State Ethics Commission get on this document to begin with? And not just the lead page, but every consecutive page of that document.
That would be a question for Judge Doyle. It's Judge Doyle's legal bill. I don't know why it's labeled that way. I presume it was in error.
Do you have any idea then, and you may have the same answer to that. And how it came to be captioned as it was in a case related to State Ethics Commission
Well,
versus several.
there are two answers to that. The first is, I don't know why Judge Doyle described anything on that legal bill the way he did. However, to the extent that, and this gets right to the heart of the problem, to the extent that that caption was trying to describe something that was non-public or attorney-client privileged, that's a disclosure that's different in kind to the affidavit about which you were speaking. It's exactly that type of information, and in fact, I don't remember what he called it, but I think I understand your question. Those are the reasons that the law recognizes bills, legal bills, and bill detail as privileged and confidential.
I can probably add a little bit to what Mr. Harrison was discussing. The documents themselves that you're talking about were produced by the Allegheny County District Attorney's Office as part of discovery. So they were already essentially public documents. So Judge Doyle then reviewed those documents as part of his analysis.
Okay. The caption itself referred to Senate Republican Caucus, Senator Jane Orry v. Pennsylvania State Ethics Commission. Okay, so that's, I mean, and that leads to part of the conclusion, because you're, I'm sure, aware that there actually was no case that existed at that time with that caption.
As far as I know, that's right.
Okay. So which potentially would lead to an understanding of confusion about exactly what the document referred to and why it was sitting at the Ethics Commission.
Well, that's true, except that it doesn't take into account the actions of the commission's lawyer, which I again credit. As our understanding of the timeline goes, this document was received, immediately brought to the attention of the staff attorney, who immediately recognized, we're not supposed to have this. This was an accident. We're not supposed to see this. So I'm going to call the law firm, let them know we got it, let them know it's here, let them know I'm sending it back to them. So, look, I'm not telling you that that caption is not confusing. Frankly, I don't know what it is. But it wasn't so confusing that a commission staff attorney didn't realize in substance what he had before.
Okay.
May I interject at this
Sure.
point?
I'm sorry, I can't hear you.
Mr. Chair, may I ask a question?
Yes.
At this point, thank you. You keep characterizing what a staff attorney believed, and it's very different from my understanding. I think there's a lot of conclusions that you're reaching, and I'm wondering if you have anything to point to support your conclusions of what the staff attorney believed.
Ma'am, I have, to support my conclusions, one, my discussions with Judge Doyle, who, if this was some sort of formal evidentiary hearing, he or his secretary could testify as to what the staff attorney said to staff at Judge Doyle's law office. I also have the letter from the staff attorney enclosing the bill saying, here it is, we're returning it to you. Have I talked to that lawyer about this issue? Of course not. I suppose we'll find out what was going on in his mind. But again, those are the types of questions that we were seeking answers to. If there was some sort of misperception by the caucus or Judge Doyle of the facts, my very first letter, frankly all my letters, that's the dialogue we were seeking to have. And you can understand why it's frustrating when you're asking for an explanation, not simply because you want to pick a fight, not just because you want to get mad, but you want to understand. To not get a response and not get an explanation. And I don't know what that young attorney will say, but we wanted to. We were asking to be told that. So all I have to go on right now is the letter to Judge Doyle's office, and I can read it. for everyone's benefit. Dear Ms. Scully, or Scally, I think that's the assistant at Judge Doyle's law office, pursuant, there's a typo here, pursuant to our telephone conversation of earlier today, I am returning the correspondence which was inadvertently forwarded to the State Ethics Commission, respectfully, the attorney from the commission. Objectively, we read a letter like that, we're told what we're told about the conversation with Judge Doyle's staff, and our understanding is, okay, they did the right thing. They got it. They know it was a mistake. However it got there, somebody fouled up and sent it to the commission, but they got it. They turned around and sent it back. Problem solved.
Mr. Haverstick, you've mentioned the rules of professional conduct, and I'm sure you're well aware that ordinarily, if an attorney's office would send something like this to someone else by accident, it would probably be the better practice for that lawyer to follow up with a phone call with instructions of how that document was to be handled. Isn't it true that in this case, no attorney from the Mancini firm ever contacted the State Ethics Commission and said what to do about this? The only people who were trying to find out what was going on were people at the State Ethics Commission.
Well, I can't answer what other attorneys may have spoken with folks at the commission. I don't have access to that information. All I know is that there was a discourse between the staff attorney at the commission who assured someone at Judge Doyle's office that the bill would be returned. Beyond that, if there were other conversations, I'm not aware of them. But even if there weren't, I think that wraps back in, Ms. Hitty, to my earlier comment. You and I can debate what the rules say, what the cases say, what the statutes say. But it's a question of more than that. It's a question of, if we were reversed, would you feel ill-used if I did this to you? I mean, I think that's really the fundamental question that I'd like to put before the commission.
Send a bill back?
But then keep copies after I send it back, and do whatever with those copies. That's the question I put before you.
Can I say something? No, we're not a facilitative body. We're an investigative body. Okay? You know, and whenever you're investigating a particular case, anything you get in reference to that case, you keep. You keep. You don't throw it away. We also followed up just a little further. Mr. Contino contacted Senator Scarnati's office. Let me just back up and say something. I was in the legislature for 22 years. The political climate was terrible in Harrisburg, with people being indicted and so on. If I were in the legislature today, and I got a call from the State Ethics Commission, from my staff person, they would immediately tell the legislator, because they're terrified of the State Ethics Commission right now because of all the things that went on. We not only called one time, we called Senator Scarnati's office the second time, and the second time it was even explained to the staff person, the legal person, why we were calling. Never got a phone call back. Now, I will say this from my experience. I can't imagine a staff person getting 2 calls from the State Ethics Commission in this political climate, not telling somebody higher up, we got a call from the State Ethics Commission. Do you think I should return your call? I can't imagine a staff person getting 2 calls right now with guys being indicted, convicted, sentenced, and not telling your boss or whoever, we got calls from the State Ethics Commission about this matter. I'm sure that staff person just didn't get those calls and said, not important, not calling back. So we have followed up. We've tried to be helpful. And yet, you know, so we're not all wrong. We've tried too.
Well, sir, first, I don't know which staff person in Senator Scarnati's office.
We know.
We know.
We can give her the name.
Well, I think what you're referring to probably is that as soon as Mr. Contino knew of the bill, he called Russ Faber, trying to find out why the commission was being billed all this money, and Mr. Faber didn't know. and we told this to Mr. Scarnati, he knows this, and Mr. Faber suggested calling the council. And so Mr. Cantino called Ms. Malpese, I believe is how you say her name. Malpese, thank you. Twice. No response. And so it does come across, I guess, a little hard to take here that we're being criticized for what you think we didn't do, when what we were trying to do didn't even get a response.
Well, I'd say this, in response to your points, both of you. What communications were happening internally among the caucus and caucus lawyers, you wouldn't be privy to, just as I'm not privy to the communications you were having. And I could say with forthrightness to you all that once it's learned that Judge Doyle's assistant had a conversation and a letter and a returned document from the commission, the collective believed that the matter had been handled and closed. And that was where it stopped. We didn't see the need for follow-up after speaking and conversing with Judge Doyle and being told about the conversation with the staff attorney and then getting it back with this letter.
So basically, the caucus is outraged when the commission doesn't respond to your letters, but we should just take it and eat it when you don't respond to our calls. Is that what you're saying?
No, I'm not. And if you choose to be angered or outraged by not returning phone calls from Donna Malpese, I think that's something that you should raise with her. However, it doesn't have anything to do really with respect to the issues we have here. It feels to me like a smokescreen. We're talking about two different things.
Well,
We don't agree with that, sir.
Okay.
At least
I don't
Commissioner
agree with
Balger
it.
doesn't.
I don't agree with it.
If
I have no further questions, Mr. Chairman.
I'm sorry, Mr.
I have no further questions, so if any of the other commissioners.
Can I just ask one more question? If you were conducting, if you were involved in conducting an investigation, I chair the Granite investigation, which was the largest investigation in Pennsylvania. When we got anything at all from anybody in reference to the case that we were reviewing, if somebody called from Minnesota and says, you know, that Granite thing, that was a wrong letter that we sent, would you send it back? I might have sent it back, but we're going to keep that information. If we're investigating the case, this is what we did. We're investigating Senator Warren's case. Anything that you get in reference to Senator Warren's case is an investigative body. You don't just send it back because a person calls and says, we made a mistake. We may have agreed that he may have made a mistake, but we still keep that information. And let me just say one other thing. When the AG's office, for example, prosecuted Dion, DeLeese, and so on, Purcell, and so on, I'm sure they were looking at the respective caucuses as to whether they were paying their legal fees. And I am certain that the AG's office in Pittsburgh was reviewing any amounts of money that the Senate caucus was spending on Jane Orry. There's no doubt in my mind, okay? So you people were outraged that they have this information. They were going to get this information. But in addition to that, under the Pennsylvania, I believe the law was passed by Christiana, where everything is transparent and so on. Why wouldn't the DA's office have access to that information?
to a privileged document, to an attorney-client privileged
The
document.
taxpayers are paying for that bill,
Well,
okay? Are the taxpayers not paying? So that should be transparent.
I think what Mr. Colafella may be referring to is the Levy case, which, of course, you've lost it so
Yes.
far.
We all may have the answer to that very shortly, sir. But right now, the answer from our Commonwealth courts is that legal bills are redacted. And that information is considered attorney-client privilege, and therefore it should be redacted. It does not have to be disclosed, notwithstanding whether it's paid for with public dollars or private dollars. Now, that may change after the Levy case, but right now that's the law of the Commonwealth. And that didn't change in the Orry case at the sentencing, and I know I was there. By that logic, sir, any legal services provided to, by inside or outside counsel of any nature, if they're paid for with public dollars, lose the protections of the attorney-client privilege. Now, I can tell you that issue's coming up too, and we probably are all on the right side of that issue, I think, in this room. But again, I don't quarrel with this commission's ability or desire to investigate. As I said, there are rules, there are processes, and I haven't, frankly, heard anyone explain to me yet when a subpoena, not a grand jury subpoena, a trial subpoena came into the commission asking for a document that is recognized by the courts of this Commonwealth as being legally privileged, which was flagged as privileged and inadvertently produced by an attorney from this commission, why no one let Judge Doyle or the caucus know that subpoena came in. Why no one picked up the phone and said, we got a subpoena, you've got 24 hours, we're turning the document over, if you want to do something, great, we're going to turn it over, but if you got to do something, you got to do something.
Mr. Haverstick, just I think for the sake of the folks who are present, the public listening in on this, I think we need to give a little bit more of the law here too, to be fair. And of course, as you are well aware, when a document is communicated in the presence of a third party, in this case directed specifically to the State Ethics Commission in what appeared to be a bill to the State Ethics Commission for payment by the Commission, any claims of privilege, in my legal opinion, and I know we disagree, but those claims of privilege are waived. And I think in addition to that, the point that one of our commissioners made earlier, I think it was Commissioner Volk, about when you look at this invoice and you compare it to the affidavit of Judge Doyle, the motion that your firm filed as a matter of public record, going into tremendous detail about the nature of the services that Judge Doyle provided, the legal issue that was involved, I'm frankly at a loss to figure out what in this bill wasn't already public knowledge, other than perhaps a specific number of hours that were being billed.
Ms. Hitty, you're right. We have a fundamental disagreement of the law, and with respect, I don't believe you're right. I think that it was, I measure my words here. I think when the first reaction from the commission and a staff attorney at the commission is to recognize that this was an accident and inadvertently produced legal bill. I think for the commission to take the position that you were confused about whether someone was seeking to have the commission pay that legal bill pushes the bounds of what any of us really should fairly be expected to believe. With respect to what's in the legal bill and whether it's privileged, you're right, we do have a difference of opinion. My opinion is backed by Commonwealth Court jurisprudence and very likely, in about a month or so, Supreme Court jurisprudence. I'm not sure where yours is.
Well, mine is based on case law as well, and I wish I could predict with such certainty what the Supreme Court would do in a particular case, but you and I will disagree on this, and that won't change.
It's an interesting, it's an intellectual debate that I look forward to hoping is resolved one way or the other in the near future, and then one of us can say we're right and the other can say we're wrong.
Okay. Commissioner Bergen, do you have any questions?
I do not at this time.
Any more, Mr. Caulfield? Commissioner Caulfield? Commissioner McCurdy? Okay. Thank you very much. As I said before, and I want to say it again, as far as this commissioner is concerned, we've been informed all the way what's going on by our staff. We feel we've done nothing wrong, illegal, and I stand by that today, and will continue to do so in the future. We appreciate you being here today, and by the way, say hello to our good friend, Mr. Fryman.
I can take the plaque back with me if you want, but you'd probably rather give it to him yourself.
Right.
Thank you for the opportunity to speak with you all, and good luck.
Thank you.